Okay, thought experiment. Our class 12 board exams. Now, we write the exam in a different school with teachers from other different schools invigilating. Why? Because our teachers have grown to care about us and they can't be expected to act impartially and objectively. But imagine if you were asked to somehow self-invigilate or assess your own papers. How neutral or objective would you and all your classmates really be? Now apply the conclusions of this thought experiment to the only thing I like to talk about, the government. Now see, in a notification dated the 6th of April, the Ministry of Electronics and Information Technology notified the IT Amendment Rules 2023, which gives it the power to notify a fact-check unit of the central government that will identify fake, false or misleading online content with respect to any business of the central government. Sounds a bit strange, no? So let's look at the government's plans for our Facebook and Twitter accounts from two lenses, the logic and the law. Now, in a democracy, there is supposed to be a separation of powers between the executive, the legislature, and the judiciary. So as the board exams example tried to show, logically, the executive, that is the government, cannot be and do everything everywhere all at once, right? I mean, just simple logic. Can the government really be the complainant in a fake news case about itself, then play the investigator, and then judge for itself whether the claim is misleading or fake? Additionally, intermediaries, including social media ones like Facebook or Twitter, risk losing their safe harbor protections if they fail to or decide against taking actions on content identified as fake or false by the notified fact-checking unit. Safe harbor protection is what protects online platforms such as Facebook or Twitter from being held accountable for the content posted on them by their users. Another problem is that the IT rules do not define what constitutes fake or false or misleading information, nor do they specify the qualifications or hearing processes for a fact-check unit. Therefore, a word like misleading being used in a fact-checking context can give the government sweeping powers to take down anything that may be seemingly harming its own interests, assigning guilt to speech that could otherwise be innocent and protected. Now, the Internet Freedom Foundation has stated that the notified amendments are in gross violation of the Supreme Court ruling in Shreya Singhal versus Union of India 2013, which had stated that when there is no clear guidance on the matter, any section in a law which creates an offence and which is vague must be struck down as being arbitrary and unreasonable. This was the same landmark ruling that struck down Section 66A of the IT Act, which criminalized the sending of offensive messages through a computer or other communication devices. Experts opine that the BJP government's attempt to impose a fact-checking unit is a backdoor method to reintroduce Section 66A. Additionally, the Editors Guild of India has pointed out that there is no mention so far in the rules about what the governing mechanism will be for the fact-checking unit. I mean, so many questions arise. Will there be judicial oversight, the right to appeal, adherence to Supreme Court's guidelines from the Shreya Singhal case? Therefore, what appears to be most at risk here is dissent, something that our current Chief Justice of India called the safety valve of democracy. The new rules seem to be the central government's early steps to crack down on dissent as